Mitchelle Angela Blair, defendants charged in count 1, child abuse first degree, count 2, child abuse first degree, count 3, child abuse first degree, count 4, child abuse first degree, count 5, child abuse first degree committed in the presence of another child. Appearances for clerk, please.
Karen Goldfarb, Your Honor, appearing on behalf of the people.
Good morning, Your Honor. Wyatt Harris on behalf of Mitchelle Blair.
Okay. It's been brought to the court's attention that the people have also filed an amended complaint. The defendant needs to be arraigned on those charges. Those charges are count 1, homicide, murder, first degree premeditated, count 2, homicide, murder, first degree premeditated, count 3, felony murder, count 4, felony murder, count 5, torture, count 6, torture, count 7, child abuse first degree, count 8, child abuse first degree, count 9, child abuse first degree, count 10, child abuse first degree, count 11, child abuse first degree committed in the presence of another child.
Sergeant Spurshaw will swear to the new complaint, Your Honor.
Okay. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You swear or affirm that the facts and circumstances contained in this affidavit are true and accurate to the best of your knowledge?
I do, Your Honor.
All right, Mr. Harris?
Your Honor, it's my understanding that Ms. Blair has been arraigned on counts 7 through 11. The amended complaint contains counts 1 through 6 as new counts. We waive formal reading of that information and stand mute.
Court enters the plea of not guilty. All right. We had some sidebar matters that we discussed as well I think needs to be put on the record. Mr. Harris?
Yes, Your Honor. I am asking the court to grant my motion for competency to waive Miranda, competency to stand trial, and criminal responsibility. I would be asking for those evaluations from the state. I would indicate to the court that I've also submitted to Judge Kinney, the presiding judge of this court, a order to ask for an independent psychiatric evaluation.
Let's take it one by one. First, as it relates to the competency to stand trial and the competency to waive Miranda and criminal responsibility. As it relates to the competency to stand trial, what's your basis for asking for that? Are you saying that the defendant isn't understanding this process as she stands here now?
I believe so.
Okay. All right. And as it relates to criminal responsibility, that's a trial issue, but since we're going to refer her for competency to stand trial, we might as well do them both at the same time. Okay, no issue with that, and no issue with the competency to waive Miranda. Now, why have you requested an independent before we even have any findings from the forensic team?
Well, one, for expeditious purposes in terms of trying to make sure that while the competency evaluation was going on, the independent evaluation was going on, so I wouldn't have to ask the court once the results from the state come back for an independent.
It just seems to me to be a bit presumptuous in that regardless of what the doctor is going to come back with, you're requesting an independent.
And I'd agree with the court, it is a bit presumptuous, but I think that I would prefer that that evaluation take place in conjunction with the state's evaluation so that I wouldn't have to come back and extend this time asking for an independent. And it's not uncommon in this court, Judge, for independent evaluations to be asked for at the same time of state evaluations.
It's uncommon to this court.
Okay.
As to this judge, I've never done anything like that because it seems like we would just be spinning our wheels. Why are we doing the original examination if you're just going to question what those findings are? That regardless, I mean, those findings might be well-founded, and you may agree with those findings, or not.
I would indicate to this court also that after having discussions with my client, I think an independent evaluation is warranted.
But you don't even know what the findings are. They may find her incompetent.
They may.
And so then we have
I'll leave it to the court's discretion. I
But
took
you've
that
already
action.
had it signed by Judge King.
He hasn't signed it yet. I'll
Oh,
leave it to the,
that's what you said.
there's an order sitting on his desk to be signed.
Well, why would you bring it to him instead of me?
Because it's my understanding that the county is the one that would be paying for the psychiatric evaluation, not this court.
I think I'm going to hold off on that for right now because we don't know what they're going to come back with. And they may very well find that the defendant is incompetent. And now you've cost the county monies for an independent exam that wasn't even warranted. Ms. Goldfarb, your take on this?
At the circuit court level, it does seem expeditious because it just delays things. At this point, I don't know that it's necessary. And I think it's a discretionary issue with the court. I just think it's the court's discretion.
I mean, I'm all for things being handled expeditiously, but I don't want to waste the county's limited resources either. And like I said, the forensic examiner may find this defendant incompetent to stand trial, and at the same time, we're paying for her to be examined by another doctor who would presumptively reach the same conclusion.
But I would also indicate to the court that the forensic examiner may find her competent.
But we don't know that.
Well,
They may both find her competent.
that's true, but if the forensic examiner finds her competent, then I'm sure I'm going to have to ask this court for an independent evaluation, or at least ask this court for an independent evaluation.
I'll tell you what I'm going to do. I'm going to grant your request, although it seems quite wasteful, but I don't know a lot about this case. I purposely tried not to read too much about what's going on here. But there's a good chance that the forensic examiner probably may find her competent. And so then I would like to fast track this as much as we possibly can.
Thank you, Your Honor.
Your Honor, can I make a suggestion, a solution that would help both sides? The independent for competency would be expeditious in that we would have both evaluations. If we need to have a competency hearing, it would be, we could do it. The competency to waive Miranda and competency and criminal responsibility are trial issues. They raise a question of that for a prior act, and may not be necessary for the independent to do that at this stage.
Well, I would indicate to this court that if the independent psychiatrist is evaluating her, I'd rather have him evaluate her for all of those so that we don't have to wind up having him call him back to evaluate the statement and also the criminal responsibility.
Still expending more of the county's limited resources.
Well,
Having the doctor re-evaluate her again. When you have her right there, you can do everything at one time. So I would agree with defense counsel on this, although the prosecutor's right, those are trial issues. But since they'll have her, might as well do everything at one time. Okay. All that being said,
Your Honor, I have another matter for the court. I have an order asking the court to release the Kids Talk video of the two children that were interviewed. I have talked with and presented to the prosecutor that particular order. I feel that it's necessary that I have sufficient time and opportunity to review those interviews. I'm not sure how long they took, but I would like a copy. I understand the concern of the prosecutor's office for confidentiality, and obviously we would observe that. I would only allow an individual that would be responsible to this case, i.e. Possibly the independent psychiatrist in this particular matter, but no one else to see those particular videos.
an independent psychiatrist,
The independent psychiatrist that would be evaluating Miss
why would they need to view the Kids Talk?
That's just an example, Judge. I would understand, or I understand that I would not allow anybody that isn't tied to this case to review that. And I could, if the court wants me to give permission for someone to do that beforehand, if I thought it was necessary, I will do that.
Your Honor, anybody who's tied to this case is really not what the protective order says. It says consult and only consult, and this should not be released to members of, or viewed by members of the defendant's family, members of the defendant herself. It can't, and it is to be viewed and returned to me only. This is,
How long and how many tapes are we talking about?
there's two of them.
How long are they?
About, maybe a total of 3 hours, under 3 hours.
A piece?
No,
Oh, okay.
in total, under, a minimum of 3 hours.
How difficult would it be for Mr. Harris to come and view those at the prosecutor's office?
I would be glad to make those arrangements for Mr. Harris. The protective order is consistent with the statute, and it's, you know, we have to, comply consistent with the statute, but Mr. Harris, I think, does understand that they're strictly confidential. They will never be released by the prosecutor's office to any person, and he may not do so either.
I do understand that, Your Honor. I have in the past, and courts have approved that particular order. It would just allow me to sit down in the quiet of my office to be able to review and go over those tapes, and I would definitely return them right back to Prosecutor Goldfarb.
Okay, the order itself, Ms. Goldfarb, do you have any objection to it?
No.
Court will execute that order. All right, now we have the matter of setting this for review. Since both doctors will be examining the defendant at roughly the same time or simultaneously, I guess we'll be safe in setting this out for 60 days.
It seems to be reasonable.
That's what I anticipated, Your Honor.
June 2nd?
What did you say?
June 2nd?
No, Your Honor.
Yeah.
No.
Can we make
I'm
it,
sorry. I have a trial in Judge Heiss. I can't.
Judge, is it possible we could make it sometime the week of the 25th of May?
That's a little early. I'm not sure that both doctors will be done by then.
Because I will not be available really until June the 15th. I'm out of the country for 2 weeks the 1st of June.
How soon have our forensic reports been coming back? They've been coming back a little earlier for 60 days, huh? Because we can't move so much. You say May 25th?
Sometime the week of May 25th, probably if we went to the
I hate
28th.
to set it for the 25th and then have to adjourn it again. And that's Memorial Day.
No, I'm talking about like the week of the 25th.
Your Honor,
like
I'm not going to be available. I'm going to be in trial also that week. My first available not-trial week is June 8th.
When do you come back?
I come back on the 14th. I can be available on the 15th if the court wants.
You're going to be preparing for this case
Can
while
we
you're on vacation. That's some vacation.
Well, Judge, I presume
You've
that...
done that before, though.
Yeah, I've
The
done
last
that
time you
before
did
this
a case,
court.
You're always on vacation, as a matter of fact.
Your Honor,
I need to start hanging with you. Ms. Goldfarb?
yes, would you consider doing it on the Friday, because I will be in trial on the 15th.
I'm
On the
available.
19th? I'm
Let's say we get two new attorneys.
I work really hard.
I know you do. Too hard.
Judge, I'm available the 19th.
The 19th?
Yes.
Is that the day you're talking about, Ms. Goldfarb?
That would be awesome. Excellent. Thank you very much.
Calendar on my desk. I'm trying to remember. May or June 19th?
June 19th, Your Honor.
We'll be ready, Your Honor.
Let's make sure everything is ready. The autopsy report,
Everything will be ready.
no stipulations to anything as of right now, is that right?
Not as of right now, but Mr. Harris and I will certainly meet.
Any discovery issues at this time?
Mr. Harris?
At the moment, Your
Except for
Honor,
Kids Talk tape.
At the moment, I have received discovery from the prosecutor. I haven't gone through it thoroughly, but I will talk with the prosecutor to make sure that everything's
Make sure all issues are resolved by then. The independent doctor will be?
Yes.
Dr.
Oh, it
Miller?
will be Dr. Gerald Shiner.
Dr. Gerald Shiner. You have an order to present for Dr. Shiner?
It's presented to Judge Kinney. He has the order with him.
Okay. And any other issues? All right, the court is going to remand the defendant in light of the new charges that have been added. The defendant will be remanded to the custody of the Wayne County Sheriff. June 19th. Thank you. Going back to the
Here's a sign in there. You're good? Oh, here you go. I got a straight waiver.
Straight waiver?
Yeah.
Did everybody sign off?
Yeah. How you doing, Judge? Welcome back. Missed you.
Glad to be home.
Yeah, I say that when I go to Oakland County to try to do a criminal case. I get back to the steps here and I breathe a sigh of relief. I go, it's good to be back on these steps. You do.
Hey, Judge, how you doing? Good to see you. Oh, all's well, man.
Well, you must have just come back from vacation.
Yeah.
Well, I missed 21 days.
Everybody taking vacation.
Well, you're working too hard.
What's going on with that?
You're working too hard.